Good afternoon, dear community organizations and partners. Welcome to this information session. So the Government of Canada's Temporary Foreign Workers program has provided 2.18 million in funding to Kairos Canada to support and help empower temporary foreign workers, primarily in the agricultural sector during the COVID-19 pandemic and concluding on December 2021. So Kairos used the Government of Canada funding to expand their support and services to temporary foreign workers by partnering with organizations in the Atlantic provinces and in Ontario. And in Ontario, for example, Kairos partnered with CARE for International Workers that is sponsored by the Windsor-Essex Bilingual Legal Clinic to develop this project. So CARE is made up by 8 agencies, now 9. We have the Consulate of Mexico in Leamington, the Windsor-Essex Bilingual Legal Clinic, Occupational Health Clinics for Ontario Workers, OCAO, Windsor-Essex Compassion Care Community, the Meta Collective Meditation and Wellness Support, the Temple La Buena Semilla, the Neighborhood Organization, TNO, the Windsor-Essex Community Health Center, and the Frontier College. CARE will participate with 6 of its 8 partners, or 9 now, to develop this project. So today, Grace Bruce, the Grace Bruce Community Legal Clinic is going to provide us with information about rights for temporary foreign workers under the Employment Standards Act. Our speaker has been is a lawyer and advocate for workers serving the communities of Mississauga, Waterloo, region, Gale and Wellington County and Grace Bruce counties. Since articling in the Community Legal Clinic system, she has committed her career to serving the most vulnerable workers and pushing for greater protections in the workplace. So now, welcome. We are going to give the great welcome to Joanna Mullen. She is the lawyer from the Grace Bruce Clinic. So hi, Joanna, thank you for joining us. Thank you for to be the speaker of this webinar, and you can start now. Thank you.
Sure. Well, thank you so much, Francie, and thank you all for attending today. I'm going to share my screen and then we can get started going through the information that I have. All right, so I'm also going to pull up the chat because there are aspects of my presentation that are interactive where I would like for those attending to maybe provide some responses. There's some true or false sections. So as we go through the slides, please feel free to answer in the chat, or you can unmute yourself. Since we're a relatively smaller group today, I think we can be pretty casual and have more of a discussion around rights and workplace for temporary foreign workers.
Joanna, sorry, the presentation is screen. I mean, we cannot see the whole presentation.
The screen is?
Yeah, the screen is I don't know. No, the screen, I don't know what happened with the screen, but it looks like the letters are big, but they didn't fit into the screen. So probably, I don't know what you have to do. Maybe, David, you had some advice about the screen. You are the technological.
Maybe stop the share and start it again. You never know.
Right.
I don't know.
2 years on Zoom and I'm still figuring things out,
Yeah. Oh my God, sometimes it's crazy.
Is that better or is it still the problem?
Oh, perfect. Now perfect. It's perfect.
Okay, great.
Thank you.
Okay, so if something goes wrong, just let me know, okay? All right, so I'm going to just commence with a land acknowledgement to root our discussion today in the historic and present continued exploitation of Indigenous peoples in Canada. So I'm going to base it off where I am presenting from, which is in the town of Erin, a municipality in Wellington County. This land is the stolen ancestral territories of the neutral Anishinaabe and Haudenosaunee nations. This land and all of its people are covered by Treaty 19, which is also called the Adjutant's Purchase. What I know about the Adjutant's Purchase is that it was an inherently unfair agreement in which the white colonialists took advantage of the extreme poverty that had been precipitated by colonialism. And I also want to recognize the continued exploitation that has flowed from these treaties and the oppression of Indigenous peoples. I also recognize the intergenerational trauma that was caused by the residential school system that permeates to this day. As I live and work as a settler on this land, I recognize my obligation to work to repair the harms perpetuated by Indigenous communities or perpetuated against Indigenous communities presently and historically. All right, so the presentation today is going to provide legal information, but it shouldn't be understood to be legal advice. And the law is only current to today's date, especially given the pandemic and so many things being in flux. It's entirely possible that 2 months from now, the information that's in these slides may be out of date and not relevant. I'm also going to be focusing only on the rights of workers in Ontario who are covered under provincial employment laws. The reason for that is that most temporary foreign workers are in types of jobs that are provincially regulated, not federally regulated. Oh, okay. So what are the laws in Ontario that relate to employment and specifically provincially regulated work? So the Employment Standards Act is a key piece because it provides the basic rights to workers in Ontario. Then there's the Occupational Health and Safety Act, which regulates health and safety issues in the workplace, which won't be covered in this presentation, but will be covered in a presentation on December 3rd. There's the Human Rights Code of Ontario, again, will be part of a presentation on December 3rd. The common law, which is court-made law or case law. Then there are industry-specific laws and regulations, as well as the Workplace Safety and Insurance Act, which won't be discussed today. Today's presentation is going to focus only on the Employment Standards Act. So to start off, I thought I would begin with going through a true or false myth busting exercise. So please feel free to unmute yourself and answer. Unfortunately, I had to reduce the chat because I suspect that might have been the reason why my slides were cut off. So if you want to participate, feel free. If not, that's completely understandable as well. So, all right, true or false? My employer can ask me to agree to sign away my rights under the Employment Standards Act.
False.
No.
Yes, you're correct. It's false. And so this is certainly something that we see with temporary foreign workers is that they might sign contracts that try to get out of the standards in the Employment Standards Act. So it's always a good idea, if you can, to have a copy of your employment contract or to speak with a lawyer to find out what your rights are and whether or not your employer is following the law, because it is illegal to try to contract out of what the Employment Standards Act says. And of course, throughout this presentation, we'll learn a bit more about what the Employment Standards Act says. Okay, true or false? It is illegal to be paid in cash by your employer, by your boss.
False.
That's right, it is false. So the Employment Standards Act allows for workers to be paid through a variety of methods. But what is important is that the employer provide you with pay stubs and make the correct deductions off of your pay stub. True or false? My boss doesn't have to pay me when I am being trained.
False.
That's right, it is false. So workers are entitled to be paid if they're performing work that benefits the employer. So there's no such thing as an unpaid tryout or unpaid training. If you're doing productive work, that's to the benefit of the employer, you're entitled to be paid for that time. All right, so let's dive in a little bit more about what the Employment Standards Act says. Employers must maintain and keep records, such as a worker's hours of work and employee vacation time. But as I've highlighted here, it's always a very good idea, especially for temporary foreign workers, to keep track of their hours as well. Because of the different ways that workers can be paid, especially if they're working as harvesters or farm workers, it can be important to know how many hours you're working to make sure that for every hour you're working, you're at least receiving the minimum wage, even if you're being paid, say, per pound or based on the work that you're performing. As I mentioned, employers must provide pay stubs setting out the pay period that you're being paid for, so the amount of days that this paycheck is dealing with, the gross wages paid, the deductions that come off, so your EI, your employment insurance deductions, Canada Pension Plan deductions, and federal tax, the net wages, meaning what actually comes into your pocket, and any vacation pay that's owing for you. We've talked about the fact that you're entitled to be paid for training, and that the Employment Standards Act explicitly tells employers that they can't have workers sign away their rights under the law. I've provided up here an example of a pay stub to just give you an idea about the information and how it should look when you receive one. So as you can see, the pay period for this worker, Jill, is November 1st to 15th. So that's a 2-week pay period. Her regular wages are calculated at a $20 an hour rate of pay. So you can see the gross amount of wages, so 80 hours at $20. Now she worked 10 hours of overtime and at time and a half, so 1.5% of $20 is $30. So she's receiving 10 hours of overtime pay, and we'll talk a little bit more about what overtime pay is coming later in the slides. Her vacation pay, any bonus or stat pay, and then the total income. And then on the other column, on the right-hand side, we see the deductions that have come off. So the Canada Pension Plan deductions, employment insurance deductions, and income tax have all been correctly deducted. And it shows here what came off her paycheck and then what her net income, meaning what is going into her pocket at the end of the day on her pay date. So when you're looking at your pay stub, this is the information that you should be seeing there. All right, another true or false. Some workers are not entitled to minimum wage, overtime, or time off on the weekend.
True.
Yes, you're right. It is
partially true. I think they're entitled to minimum wage.
So it depends. There are some categories of workers who are actually not entitled to minimum wage at all. For example, farm workers have no entitlement to the minimum wage. And then
You're sure about that?
Yes. And then harvesters, as we know, also have exemptions. So if you work on a farm harvesting fruit, vegetables, or tobacco for wholesale, retail sale, or storage, you're not entitled to these things. So daily and weekly limits on your hours of work, daily rest periods, time off being between shifts, weekly, bi-weekly rest periods, eating periods, or overtime pay. But harvesters are entitled to public holidays and public holiday pays after you've worked for 13 consecutive weeks, and vacation pay once you've been with the employer for at least 13 weeks. And those weeks don't have to be consecutive. So for harvesters, you're generally entitled to minimum wage, but if you're paid on a piecework basis and the rate is high enough that you could earn at least minimum wage with reasonable effort, then you don't necessarily have to be paid minimum wage, as long as it's possible that you could earn minimum wage with reasonable effort. This gets very complicated and can be often exploitative for harvesters. So it's always a good idea, if you think that the piecework basis, the rate that you're experiencing is unfair and is not reasonable, to seek legal advice. I'm just briefly going to go back to my last slide, because it talks about in more detail these exemptions. So while we know that the Employment Standards Act is meant to provide basic minimum rights to all workers in Ontario, at least that was the idea when it was created, over the years, we've seen a huge encroachment on rights of workers, to the extent that a 2016 study found that only 24% of all workers have full coverage under the Act. So what that means is that the majority of workers who are provincially regulated do not have all of their rights in Ontario. If you're curious about an industry and whether or not it has exemptions, you can visit the Ministry of Labour Training and Skills Development website and look at the special rule tool to find out more about how those exemptions work. Okay, true or false? My employer can decide when I can take my vacation.
This feels kind of
False.
true.
Any guesses?
Like, sort of in terms of like approving vacation requests, it's kind of true, but I imagine sort of like overall saying this is your time is probably false.
So it's true that employers ultimately have the right to decide when a worker takes their vacation. So in Ontario, for workers who aren't exempt, and again, we've talked about how harvesters, for example, have exemptions to this, workers should, after their first year of employment, be entitled to 2 weeks of vacation time. Those 2 weeks of vacation time, though, are subjected to employer approval as to when you take that time, because ultimately, the Ministry of Labour has said that employers have the discretion to decide when workers can be off to ensure that they have adequate coverage to keep the business running. Now, what's important to note is that employers don't get to dictate that you take your vacation, say, one day here, one day there. You're allowed to take them at least as a week at a time, but ultimately they get the final say. Now, what's important to note is that after, no matter what, when you start work though, again, as long as there aren't exemptions, you should be entitled to 4% of your gross wages from the beginning of your employment. So while during that first year, you don't have the right to take vacation time, you are entitled to vacation pay. Now, how that vacation pay comes to you will be dependent on the workplace. Some workplaces will pay out vacation on every paycheck. Other workplaces will allow you to request your wages at a specific period of time and say, you know, on my next paycheck, I'd like to have my accrued vacation pay. Or other workplaces will pay out your vacation pay when you take your vacation time in your next year of employment, or after you've worked those 12 months and are entitled to your vacation time. Now, once you are with an employer for over 5 years, you're entitled to 3 weeks worth of vacation time, and that tops up to 6 weeks, 6% of vacation pay. Is that clear? Any questions about that? All right. Okay, true or false? I can file a complaint at the Ministry of Labor at any time.
True.
So this is one that's a bit tricky in the sense that, while technically, yes, you can file a complaint with the Ministry of Labor at any time, the ministry is only going to investigate your complaint if it's filed within a 2-year window. So you must file a complaint with the ministry within 2 years of when the incident that you're complaining about occurred. Or if you're talking about unpaid wages, the ministry will only go back 2 years from the date that you filed in terms of compensating you for any unpaid wages that may be owing. So what's important to note is that if you think your rights have been violated in the workplace, start to keep notes and keep track of your hours of work, keep track of what the violations are happening, when they're happening, and be as detailed as possible. It's important to keep those records in a safe place. So ideally not in your workplace if you can avoid it, or back it up on your phone or computer so that you can have easy access to that information. Many complaints that the Ministry of Labor sees often involve things like unpaid public holiday pay, unpaid overtime pay, or unpaid wages. And as I mentioned, the ministry has the ability to investigate these allegations if the Employment Standards Act has been breached, and to order compensation to a worker after the investigation has concluded if a violation has been found. They also have the ability to order the employer to pay things like fines or penalties for breaking the law. Okay, so here's just a recap of the answers. So it's false that you can file at any time because there is a 2-year limitation period. It is legal to be paid in cash, but it's true that some workers are not entitled to all of the rights under the Employment Standards Act. Your boss does have to pay you for training, but your boss can decide when you take your vacation. And your employer can ask for you to sign away rights, cannot ask you to sign away rights under the Employment Standards Act. Okay, so what else is set out in the ESA? So the ESA is where we find the minimum wage rates. Currently, the general minimum wage is $14.35 an hour, which was just increased in October. And the minimum wage for students is $13.50 an hour. We've had it announced by the government that there's going to be an increase on January 1st to a minimum wage of $15 an hour, and that will apply to the general minimum wage and other minimum wage rates as well. So generally, again, if your employment is not subject to restrictions, like for example, as we discussed, harvesters, there is a limit on the amount of work that you can perform in a day. So maximum is 13 hours in a day, and you're entitled to a 30-minute break after every 5 hours. In a week, you're not supposed to work more than 48 hours, or if you've signed a written agreement with your employer, it can go up to 60. And after working 44 hours in 1 week, you're entitled to 1.5 times your regular rate of pay as your overtime pay. So as we talked about when we looked at the pay stub, when you've worked more than 44 hours in a work week, you should see on that line in your pay stub your entitlement. So based on the hours that you worked and that increased rate of pay. Does anyone know what the 3-hour rule is and want to share?
Is that where if you come into work, no matter how long the shift is, if it's less than 3 hours, you have to be paid for those 3 hours for starting work?
Yeah, so close. So if your shift is intended to last 3 hours or more, and it's cut short, so say you only work for an hour and a half and you're sent home, you're entitled to be paid for 3 hours. Also included in the Employment Standards Act are public holidays, and public holidays are set out. The idea behind the public holidays in Ontario is to provide workers with a day off to be with their loved ones. And in Ontario, there are 9 public holidays, and I have set them out here. So under the Employment Standards Act, it tells us that if you work your regularly scheduled shift before and after a public holiday, you're entitled to receive public holiday pay. Or if you work on the public holiday, you're entitled to receive your pay at 1.5 times %, so a premium pay or like your overtime rate, and receive public holiday pay. Or you can agree to take another day off in exchange if you've worked that day, but you still receive the public holiday pay. The reason for this is that the government acknowledged it would be unfair to force workers to essentially take an unpaid day off. So they've created this idea of public holiday, which is kind of an averaged wage rate based on the 4 prior weeks' earnings, in order to figure out what that day's rate of pay should be. And that is what you receive from your employer on the following pay stub. So during the following pay period from where the public holiday occurred is when you would see that line with the public holiday and your entitlements there. All right. Now, the Employment Standards Act also sets out minimum requirements when a worker is terminated. So if a worker has been with an employer for at least 3 months, an employer has to provide them with written notice to terminate them, to end the employment relationship. Now, a worker can either receive working notice, where they work for the period of time that they're entitled to be aware that their employment is ending, or they can receive pay in lieu of notice, which is where they're paid for that period of notice that they're supposed to be informed in advance that the employment relationship is ending. Now, the amount of notice that you're entitled to amounts to essentially 1 week of wages for every year of service. And it maxes out at 8 weeks. So once you've, been with an employer for 9 years, your maximum would still only be 8 weeks worth of notice. Some workers may be entitled to more than just termination pay under the Employment Standards Act. So if a worker has been with the employer for more than 5 years, and the employer has a payroll of $2.5 million globally, so across the entire world, all branches of the company, or the employer is letting 50 or more workers go within a 6-month period, a worker is entitled to receive severance pay in addition to termination pay. Severance pay can be very helpful because instead of maxing out at 8 weeks, it maxes out at 26 weeks. And you would get both the termination pay and the severance pay if you're entitled to it. Any questions for me about this? Or anything else that has come up so far in the presentation? Okay, we'll keep going. So the ESA also provides for job protected leaves of absence. What that means is that if you fall under one of these categories and you need to take time away from work, you have the right to take a job protected leave, meaning that when you return from the leave of absence, your job has to be waiting for you. If it is not, it could be viewed as a violation of your rights and something that we call a reprisal, which is being punished for asserting your entitlements under the ESA. So I'm not going to go into every different type of leave that is here, but I will talk about the ones that deal with COVID-19, where there may be a connection. So under the ESA, workers are entitled to 3 days of sick leave. Prior to the pandemic, those 3 days of sick leave were unpaid. So there was no right for workers to be paid for those 3 days off. Additionally, workers have the right to take 3 days off if they have to care for a loved one, which is called the family responsibility leave. And then there's a 2-day bereavement leave. I will also talk about the infectious disease emergency leave, which was created in response to the COVID-19 pandemic. The infectious disease emergency leave is available for any worker who is under medical investigation or treatment for COVID-19, is in quarantine isolation, or has been told by public health that they have to self-isolate, or is told to self-isolate by their employer because there's a concern they've been exposed in the workplace. Workers can also take this leave if they're providing care to a family member, including for children whose school or daycare was closed because of COVID-19 when there were shutdowns, or has travel restrictions that require them to stay away from Ontario. If a worker needs to take the infectious disease emergency leave, they should give their employer notice in advance. And they may need to provide some reasonable evidence of their need to take the leave, but that does not mean that they have to provide a doctor's note or a note from a nurse. Sometimes it's enough to provide information that shows that they've tested negative or positive for COVID to show that they needed to be off for that period of time. When the leave has ended, because a worker is able to return to work, an employer has to return them to the position that they held prior to taking that leave of absence. Any questions about that?
Are you going to talk about how long this leave lasts for?
So as of right now, the infectious disease emergency leave is still available to workers. My understanding was that the leave was extended until January of 2020. Throughout the pandemic, the government has been setting deadlines for when the leave would end. But then as we get closer to that deadline and it's clear that we're still dealing with cases of COVID and high rates of infection, the deadline continues to be extended. So as of today, this is available to workers, but if a worker were to try to access this, say on January 3rd, I don't know if it's going to be available then or not. It will depend on whether the government continues to extend the leave. Does that answer your question?
Well, I'll ask a different question. If a worker goes on leave, how long can they be on the leave for?
So there's no limit. So other types of leaves of absence, you may be aware under the ESA have clear limits. So, pregnancy leave is for a certain amount of weeks, parental leave is for a certain amount of weeks. The infectious disease emergency leave does not have, there's no limit, right? And as you can imagine why that is. So for example, back in 2020, when schools and daycares closed, they were closed for several months, and it was very uncertain when, schools would be reopened. So it was beneficial at that time to not have any limits on how long the leave would last, so that it would be accessible to parents or care providers who had to be off to be with their children.
So I'm assuming then that this is unpaid leave by the employer?
So the infectious disease emergency leave is unpaid generally. There is the worker income protection benefit, which allows for 3 paid sick days while you're on the infectious disease emergency leave, and it amounts to $200 a day, but that's based on the earnings rate of the worker. So there have been other benefits that have been available, such as the Canada Recovery Sickness Benefit, which didn't overlap with the worker protection benefit, but provided other types of coverage if, say, you had to be off for several weeks at a time because either you were recovering or caring for a child. There were other types of income supports available. And I think my colleague Stephanie talked about income supports more in depth last week. So that's what is available for workers when they're on the infectious disease emergency leave. Any other questions? Okay, we'll keep going. So what should workers know about COVID-19 when they're in Canada? So this information comes from the Government of Canada website, and it talks about to avoid the spread of COVID, temporary foreign workers, as well as all Canadians, are being asked to follow the local health rules, which includes staying at home in order to avoid potentially exposing your co-workers to the virus or people in the public if there's a risk. Avoid non-essential trips in the community, keep social circles small and not gathering in large groups, wearing a mask if you're working around others or if you're socializing with others, limiting contact with people at higher risk, such as older adults or those in poor health, and going out to exercise but staying close to home. It's important to note that employers don't have the authority to limit the movement of temporary foreign workers. And like all workers, you are permitted to run errands, access services, and enjoy time off when not in quarantine, self-isolating, or restricted because of government orders. So as we discussed very briefly earlier, there is protection under the ESA for reprisal. And a reprisal is the idea, again, that you can't be punished, threatened, or terminated for asking for compliance from your employer with the law. If your rights are violated and you are trying to assert those rights and you're punished, you can file a reprisal claim with the Ministry of Labor within 2 years of when the reprisal occurred. And the ministry has the ability to investigate and award types of compensation or even can award reinstatement, although that is rarely something that we see. So that concludes the substantive portion of my presentation on the Employment Standards Act. And now I'm just briefly going to talk about the services that we provide at Grey Bruce Community Legal Clinic. So there are 73 community legal clinics in the province of Ontario. Almost every community in Ontario has a legal clinic that can be accessed by the residents of that community. Legal clinics receive funding from Legal Aid Ontario, which gets their funding from the province of Ontario. Our mandate at legal clinics is to provide free, accessible legal services for low-income Ontarians. And so the areas of practice that we can advise about at legal clinics primarily involve services that are geared towards low-income residents. So things about social assistance and financial supports, housing for tenants, and employment law for workers. We have the ability to provide information, advice, and representation on legal services that fall within our areas of expertise. So to qualify for information and advice, you have to live within the region of that legal clinic, the catchment that's covered by that clinic. If you don't, they can refer you to the legal clinic that is where you live and provide you with that information. And then again, your legal issue has to be the type that's covered by legal clinics. So most legal clinics don't practice in the area of criminal law, for example, or offer services for family law issues. And then to qualify for representation, you would have to be able to demonstrate that you are low income in accordance with legal aid policy and that your case has a good chance of success. But it's important to note that even if you're not able to receive more fulsome services from a community legal clinic, at the very least, you can get some good legal information or good legal referrals to point you in the right direction of where you need to go. So that concludes my presentation. It wasn't as long as I thought it would be. I think I was anticipating maybe a little bit more discussion, but I am really happy that I was able to share this information with all of you. And please let me know if you have any questions about what I discussed today.
Yeah, thank you, Joanna, for this amazing presentation. I had a lot of questions and also I have some comments. Yeah, because we are legal clinics, we had a lot of clients asking for different kind of issues related to employment law. So I really would like to mention to you and everybody what are the most cases that I have here in the region. And also Joanna can just help me to clarify some points. And yes, for example, in Windsor Essex Bilingual Legal Clinic, many workers in the region contact me for different kind of issues related to employment law. For example, I want to clarify that all agricultural employees working in Ontario are protected under Employment Standards Act and also under the foreign, the Employment Protection for Foreign Nationals Act. So related to Employment Standards Acts, depending on the category the agricultural employee falls into, different rules and standards may apply for the workers. The categories usually are farm employees, harvesters, near farmers, and landscape gardeners. So for example, the standards rules that apply for farm workers are different from the harvesters or different from the near farmers or different for landscape gardeners. For example, farm employees, they don't have right for vacation pay. They only have payment for regular payment of wages, leaves of absence, termination notice, and equal pay for equal work as everybody else. Harvesters, already Joanna mentioned us how are the rules about employment that refer to them. For near farmers, that means the people who is working in flowers and transportation, seeds or something like that. They have right for regular payment, list of absence, termination of notice, minimum wage and vacation. And landscape gardeners the same, except they already had one more is the eating periods, daily, weekly, and bi-weekly rest periods. So yeah, just I want to make sure because the workers, temporary foreign workers, they think that all of them, they have the same rights, the same employment rights. So when I had a client, I have always to ask, what is your activity? What is the activity that you are doing? And usually they don't know even if they are farm workers or they are near farmers or harvesters, you know, even they don't know. So usually I have to ask for the contract, the employment contract, and review what kind of activities they are doing in order to let them know what are the rights under the Employment Standards Act. So any worker, migrant worker has different activities. So there are different rights, employment standard rights under the activity that they are doing. So this is something that I want to mention important because yes, not all the temporary foreign workers have the same standard rules. They have different, apply to different, depending on the activities. Yeah, this is just a comment about what are the issues that I always had from workers. Yeah, Brian, do you have a question?
Yeah, thank you. Are we going to, at one point, talk about the Agriculture Employees Protection Act? Because most of the workers that come up through the seasonal agricultural worker program are covered by the Agriculture Employers Protection Act, along with the trilateral contracts between the Canadian government, the employer, and the supply country. So because there are some significant differences in the low skills temporary foreign worker program, the seasonal agricultural worker program, that follow both of those follow the Agriculture Employees Protection Act, and things like overtime are not covered under that. And we are limited through the contract and other negotiations in number of hours and those types of things. But yeah, statutory holidays are not paid or recognized in the Agriculture Employer Protection Act. And those are huge things. Most of the employees come for a maximum of 8 months. And because it's a seasonal program, a lot of the quote protections through the Employment Standards Act are not put into place. So it would be helpful if we could, I don't know, is it on the agenda to talk about the Ag Act?
And today the presentation is only covering the Employment Standards Act, but for sure we are going to have one about the employment protection for foreign nationals, but we don't have a schedule yet, or maybe we cannot do the presentation about the Agricultural Protection Act because we don't have enough time. Yes, that means we need to finish the project and all the webinars are already, but we for sure we would like to have one. Yeah, the next one that is scheduled soon is the Employment Protection for Foreign Nationals Act, but I really want to follow your advice, and maybe we can have next year or soon. CARE is also doing many information sessions, regardless is in Kairos project or not. We always do presentations, legal information for workers. So it's a good idea to have one about the Agricultural Protection Act. So yeah, as soon as I know when we can have one, I will let you know, and all of the people who is here in the session or other organizations. For sure, yeah, thank you for tell us, yes, for sure. Yeah, thank you. Joanna had a question about, I have some workers that, for example, call and say, I sign a contract in my country, for example, Guatemala. I signed my contract in Guatemala, and when I came here to Canada, the employer changed me the contract, and I didn't know what I signed. Just I tried to understand the contract because it's in English. So when I came here, they promised me to pay me per hour. And after 1 or 2 months, the employer changed me the payment, and they are going to pay me for piece payment. So when they do the calculations, obviously piece payment is less than per hour, right? So usually these kind of changes are prejudicing the workers, that are not good for them. It's more work for less pay. So do you have some advice about it, or do you have some clients that are the same situation like me? I usually just ask them for the employment contract in order to review the conditions. Sometimes they say, I cannot give you the initial employment because it was signed in my country. So they lost the contact in Guatemala, for example. So have you any cases like that in your clinic?
Yeah, so I think it is a common problem that I have experienced working with temporary foreign workers, where they're not given access to their employment contracts. They're not allowed to read them, or they're not translated into their language so that they can understand the terms that they're agreeing to. I think there's arguments to be made that if the worker doesn't know what they're signing, then the contract shouldn't necessarily be binding on them. But of course, that will be really dependent on the facts of each different case. And then, of course, one of the other things that we would examine, as I talked about in my presentation, is if there is an attempt to contract out of the Act. So to provide working conditions or standards that are less than what's allowed then under the ESA, that would make those provisions void and not enforceable under the law.
Yeah, thanks.
So there's a question in the chat, which is about the difference between rights for temporary foreign workers versus the rights for Canadian citizens. So if we're only focused on this idea of employment standards, then ostensibly, no, there is no difference because the Employment Standards Act applies to Canadians in the same way that it applies to temporary foreign workers. So everyone has coverage under the Employment Standards Act, whether you are a citizen of Canada or if you're a temporary foreign worker, the Employment Standards Act is for everyone. But where there's that difference that I was talking about, well, and as Francie mentioned, is dependent on the type of work that you're performing. So if you're performing work, say as a harvester, there are exemptions to your rights under the Employment Standards Act. But that doesn't necessarily mean that if a Canadian citizen was also working as a harvester, they would also be subject to those same exemptions. And there's many, many, many types of jobs that have exemptions under the Employment Standards Act. For example, my job as a lawyer, I have actually almost no rights under the Employment Standards Act. The only right that I have is to termination and severance pay. So, as I was highlighting, the majority of workers have some exemptions under the ESA, and that's applied universally, whether you're Canadian or a temporary foreign worker. Any other questions?
Just I want to ask you if we can just, because this meeting is going to be posted on Facebook in order to leave the presentation available for the temporary foreign workers. So I really would like to mention that if they need legal advice, they can contact our clinics. Any clinic that, as Joanna mentioned, has different caching areas or geographical covering. So if you are an employee, a temporary foreign worker that is not located, for example, in Windsor, you can, or we can refer you to the community legal clinics in your region or when you are living, so next to you, so you can access to those community legal clinics in order to get information or legal advice. So you can contact us through Care for International Workers, through the Facebook page, or just calling us, calling the clinics individually, or just calling Care, so we can just do referrals to everybody. The Grace Blues Clinic, Joanna, what is your caching area in Grace Blues?
So we cover both Grey and Bruce counties. So that stretches from Tobermory all the way down to say like Dundalk, and then where like Grey and Bruce counties bump up against Dufferin County and Wellington County. So both of those counties, which have a very large geographic area, are covered by our clinic. So Port Elgin, Owen Sound, Wyerton, and the regions around there are all covered by our clinic.
Okay, so if a temporary foreign worker needs assistance from you, so do you recommend that temporary foreign workers needs to have a copy of the employment contract and copies of the payment stubs, and also any warnings that they are going to receive from the employer or something else?
Certainly you don't have to have that information to talk to us. We'll talk to anyone, no matter what documents they may have at their disposal. So, you know, no one should ever hesitate. If they have questions about their rights in the workplace, they should just call us and we'll be happy to talk to them. Certainly the more information that they can share with us, the easier it is for us to provide legal advice, but we understand that that's not always possible.
Yeah, okay, that's fine. Yeah, is the service in your clinic provided in English, or they can go with an interpreter in order to get assistance?
So like all community legal clinics in Ontario, we have access to free interpretation. So although I'm not bilingual, I always have access to an interpreter if someone needs one.
Yeah, and doing this is because they need to know.
Yes,
yeah,
of
I
course.
know we're a clinic,
yeah.
but just because they are going to have access to this presentation, and probably they have that kind of questions. Yeah, if somebody else has some more questions, you are welcome to ask.
Yes, of course. And our number is here on the slide. So you can always give us a call, and I'm happy to answer any questions that anyone watching this presentation may have.
So a question on interpretation or interpreters, is Spanish interpretation available?
Yes.
Good, thank you.
All languages we had access from the Legal Aid Ontario is covering all the languages, so we can contact the organization. Is the MCIS, I think. So we can contact them, and they gave us interpretation for any languages for our workers. So that's good. Can be by telephone or by teleconference. Yeah.
I do have a question, if that's okay. Just maybe a bit around some of the data that's taken from complaints. Like, is it identified what industry workers are coming from if they do have a complaint under the Employment Standards Act? Or if you've noticed in your work whether complaints coming from employees in agriculture are denied like more often than folks coming from other industries as well. If that makes sense.
That's a great question. I don't personally have information regarding that specifically, but organizations like Migrant Worker Alliance for Change may have access to that type of data.
Hi, Francie.
Hello, Sharon.
Hi. I don't have a question, Joanna. That was, really clear, and we appreciate that presentation. But I wanted to say thank you to Philly. She's a great help with our project here in Grey County. She, I believe, she shared the voice about our project. So she blasted some newsletters with other partners, economic development, and all the stakeholders here in Grey County. So I would like to thank her. Great support for the project, and I'm happy to see her here.
Okay, thank you. Thank you. I also want to say thank you for Saul and David and all of the organizations also that are here helping us to spread this message and this presentation to everybody. So it's a pleasure for having you. I hope we can just share in our Facebook page, or David can also post it in the Empowering for Temporary Foreign Workers website, if it's possible. And yes, we can help most of the workers and organizations to understand the Employment Standards Act that is applying for temporary foreign workers. Thank you, David.
And thank you. It's Philly here, and I'm just saying thank you. I'm at a red light. I've been driving, listening the whole time, and it's been very informative, and I really welcome this, and just thanks for all your efforts.
Thank you, Philly. Thank you, everybody, for attendance to this session. I hope you can also join us to the other webinars that we are planning, and also the Kairos webinars also. Thank you so much, and have a very good day. Thank you, Joanna. We really appreciate your knowledge.
Thank you for having me.
No,
Take
it's a
good care,
pleasure for us.
everyone.
Thank you. So remember everything. Thank you, Brian. Everything will be posted in CARE and also in Kairos. So have a wonderful day, and thank you for joining us. Bye, everybody.
Thank you. Bye, all.
Bye.